A door opened in the narrow, dimly lit corridor of a Midtown hotel in March 1931, and an old woman stepped out like someone from another century. She was small, walked with difficulty, and carried the sort of hush that comes with a life measured in secrets. The bellman thought she was asking for help. The clerk assumed she was looking for change. Instead, she clutched a scrap of paper, whispered a name, and asked for a room where she could be alone. When housekeepers entered that room later that afternoon, they found trunks tied with twine, boxes layered beneath quilts, and a drawer that would not yield to ordinary inspection. Beneath the lining of a nightgown, stitched deliberately between seams, sat folded bills, sheets of currency so carefully hidden they read like a confession sewn into cloth. Under floorboards and in sealed trunks lay stock certificates, bonds, and small packages of jewelry. The inventories later tallied more than $1 million in cash and negotiable securities, a sum that in the middle of the Depression read like myth. The scene was, for a city reeling in hard times, a spectacle. Reporters called it the hoarded fortune of an eccentric dowager. For the lawyers and the would-be heirs who soon crowded the Herald Square Hotel's anterooms, it was a puzzle with clear edges. Who had the right to claim what lay behind those trunks? But the money was only the beginning of the mystery. The true question that unspooled after those bills was not how many tenders were stacked in trunks, but whose blood had been buried beneath the gowns. If this story is catching you, subscribe now and follow the full investigation that follows. The woman who would be called Ida Wood in the social columns had not always been that person. Born Ellen Walsh in a textile town outside Manchester, she arrived in New England with her family during an age when steam and cotton defined both geography and fate. She did not arrive with fortune, but with the kind of resilience molded in mill towns. A small bright nerve against cold machinery, a voice trained to obey, and the ability to make outward order where life offered little. Public records and parish registers record the basics: a name, a place, a date. But the life between those notations is where invention took place. Working as a domestic in Massachusetts, she learned a new language of presentation: how to fold a collar, how to address a hostess, how to manipulate a public gaze into a private advantage. By 1857, she had adopted a new name: Ida Mayfield. Whether she chose it for sound or strategy, for the ring of Southern gentility it suggested, or simply to step into a social claim, the change worked. In a city where some people were always looking to be someone else, she became whoever she wished to be. Newspapers of the day, especially the social pages, delighted in such transformations. She moved in society like one born to it, one society column would later suggest, and such lines multiplied until the invented life read like reportage. Press accounts claimed she danced at notable balls, that she took carriage rides down avenues studded with gaslight and gossip, that she was seen at receptions where names and titles formed a currency more durable than money. Those claims, preserved in clipped scrapbooks and library-bound volumes, served as the first layer of an identity fashioned out of attention. To understand Ida's reinvention, it helps to step outside the romanced columns and into the legal and social scaffolding of the period. The mid-19th century offered constrained options for women. Legitimate routes to independence were narrow: marriage, work in service, or a rare, precarious seam of female entrepreneurship. Marriage, in particular, had the dual capacity to lift women into new social worlds and to legally subsume them beneath their husbands' names. Laws regarding property, control, and credit were uneven across states, and a woman's ability to own and manage assets often depended on specific arrangements. For someone like Ida, wary of being legally swallowed by marriage and pragmatic about money, reinvention was as much a financial strategy as it was a social ambulation. Benjamin Wood entered her circle at this juncture, a man whose public life provided both cover and opportunity. Described in press notices as a publisher and former congressman, he had a known appetite for risk. Contemporary accounts suggest he gambled. Later commentators added that his losses were no secret. The nature of their association, in public and in record, was complicated. In the years that followed, a pattern would emerge. Stories of courtship that read like strategic alignments, of an intimate partnership that seemed to carry with it the codicils of business. Marriage relieved some constraints, but did not relieve questions of control. In the world they occupied, there were whispered negotiations about how winnings and losses would be handled. Some later documents and contemporaneous gossip indicated that an arrangement existed, an understanding that monies won under certain conditions would be treated as Ida's, while other liabilities remained Benjamin's to shoulder. Whether this arrangement was spelled out in formal notarized documents or lived as a tacit pact is debated. Surviving legal fragments and third-party testimony suggested an intentional financial decoupling designed to shelter assets. That strategy would prove prescient in years when markets and fortunes turned. Together they occupied a public life at once enviable and performative. If the social columns could be believed, Ida had brushes with distinction. Late 19th century newspapers relished anecdotes that placed her near magnates and politicians. Madame Wood received at her parlor for refreshments, declared one social note. Another hinted that she had been introduced to notable figures of the Republic. Such accounts functioned as social proof, evidence if shaky, that the world she entered accepted her. Yet another layer of invention settled into the household. Two younger women, presented as family, moved into their orbit. Emma, announced as a daughter, and Mary, held out to society as a sister. The family portrait, carefully arranged, deepened the illusion. At the time, few questioned the exact genealogy. The tableau was what mattered. Historians who have studied the Gilded Age point to the era's appetite for theater. The period rewarded appearance, said one historian who has written about social mobility of the era. Ownership of a carriage, a box at the opera, or a family name could rewrite one's social ledger more effectively than a legal deed. For Ida, such performance would become both armor and architect. The household, two women presented as kin, a husband with a public portfolio, and a matriarch whose past was unspoken, was now a narrative to be maintained. Money flowed in ways that the public could not always see. What passed for wealth in Gilded Age New York included not only cash, but also securities and claimable assets, stock certificates, deeded property, bonds carrying interest that could be negotiated. Over decades, as press engagements, gambling returns, and investments shifted, Ida began to amass holdings in her own name or under forms that she controlled. Contemporary estate inventories compiled later would list tangible assets, shares, deeds, jewelry, and bundles of banknotes. But this accumulation was not merely financial, it was also a curation of control, where women were often excluded from direct ownership of some assets. Creative legal arrangements and the opacity of private contracts could erect a private vault out of public life. The Wood household also weathered financial storms. Benjamin's fiscal highs and lows were, for a time, public knowledge. A bankruptcy in the late 1870s left a mark on their biography. Public records show creditors pressing claims and auctions being advertised, events that would have embarrassed many, but that in Ida's case, prompted more strategic steps. According to contemporary accounts, the bankruptcy did not simply ruin them. In the aftermath, certain papers indicate that assets had been shifted or already held in ways that insulated Ida. Whether she orchestrated this transfer or benefited from legal structures already in place is less clear. Surviving notices and court schedules suggest that while Benjamin's public balance sheet suffered, Ida's financial footing remained comparatively secure. The portraitable moments, carriage rides, evening calls, the occasional name on a list, comfortably sat beside the less visible work of asset protection. The period's newspapers loved a conspicuous sign of status. They reported that Mrs. Wood drove daily, entertained at private dinners, and was seen at the Academy of Music. These lines are the traces by which we reconstruct the performance, but they are not a ledger. The ledger appeared in deeds and certificates, a city lot transferred, a mortgage cleared, a bond certificate carefully stored. In the language of the period, respectability and solvency reinforced one another. Yet even as Ida projected confidence, the life she had built required constant maintenance. Social reinvention demanded continual affirmation. Each public reception, Each invitation accepted was a small stroke, wiping away the ink of a previous identity. Presenters and club secretaries answered to names and references, and the act of being introduced under a certain title mattered. She was named repeatedly in society columns, and those casual citations became, in themselves, a record. At the center of the household was the work of domestic curation, accumulating linens, cataloging silver, securing valuables in trunks. To contemporaries, this was not merely hoarding, it was prudent household management. The particularity of items mattered, which nightgowns were worn to which event, which jewelry was loaned for which portrait, which certificates went into which trunk. Over years the trunks swelled. Each trunk became, discreetly, a repository of both narrative and capital. There were interpersonal arrangements, too. Emma, the young woman presented as Ida's daughter, moved through life under that assumption. Mary, presented as sister or companion in various accounts, was another stabilizing presence. The precise blood relationships, however, were shadowed and, later, would be contested. For now, the presentation sufficed. A household of women, tethered to a matriarch who commanded attention and maintained control. Within the constricted options for upward mobility available to a woman of her origin, Ida's strategy was at once audacious and practical. By claiming a lineage she did not possess, by taking on a name that carried social freight, and by forming attachments to men of public influence, she had created a new social identity that functioned as capital. Reinvention was not merely cosmetic for her. It produced access, entrees to salons, to investment circles, to the sorts of reputational currency that could be monetized. Not everyone celebrated such reinvention. Social critics and rival columnists sometimes tisked about pretenders. Moralizing pieces hinted at imposture. But the city's appetite for novelty and its willingness to accept performance as truth often drowned out skeptical voices. In a public sphere hungry for spectacle, the line between genuine pedigree and fabricated persona could blur. For Ida, those blurred edges were indispensable. As the 19th century waned and the calendar turned toward a new century of industry and credit, the Woods continued to live where wealth and display mattered. Their name appeared in the same margins as other notable households. They attended the same events, gave the same dinners, and purchased the same social recognition. Their possessions moved in the same circles. Yet beneath that surface, the household preserved and protected assets in ways that would later confound claimants. The protective measures unfolded in incremental, sometimes legal, sometimes ad hoc ways. At moments of public peril, bankruptcy, market downturn, shifting political fortunes, arrangements that had once looked ornamental took on a different character. They functioned as bulwarks. Documents that later came to light showed transactions, transfers, and holdings that made clear the intent to shelter certain assets from creditors. Legal historians note that such maneuvers were not uncommon among those with means and savvy counsel. What made Ida's case singular was the scale of the concealment and the degree to which identity itself became an instrument of protection. By the last decades of the 19th century, her public persona had hardened into an identity that few questioned in social circles. She was, by all appearances, the matriarch of a respectable household. The wardrobe she wore, the parlors she occupied, the rituals of calling and receiving, they all served to settle rumor. Yet identity, once performed, can become its own prison. To sustain a life built on reinvention requires isolation from the very histories one has displaced. As a practical matter, it also required that some facts be kept from view. Births recorded under different names, origins left unspoken, the record arranged so that those outside the circle could not easily cross-reference a parish register with a city directory. As the years moved on, two patterns emerged that would define what she left behind. The first was the habit of private accumulation, securing bonds and certificates in trunks and keeping cash within the domestic sphere. The second was the narrative of family, a carefully staged household in which kinship had both a social function and a protective one. These patterns, when combined, would set the stage for the drama that would unfold decades later. the discovery that a woman who had died under a chosen name had amassed a fortune while obscuring the origins and claims of those who were, by blood, her kin. The story of how she amassed those holdings touches broader currents in American life, an era when a personal story could be a kind of capital, when the legal friction between husband and wife could be negotiated outside common law, and when the public appetite for spectacle could be converted into real economic advantage. Against that backdrop, Ida's reinvention looks less like a private eccentricity and more like a deliberate tactic for survival and ascendancy, an improvised social instrument tuned to the rhythms of a city and a century that rewarded spectacle. Yet even as she cultivated public acceptance, the memory of her origins remained a shadow that threatened, quietly, to intrude. For a time it did not. The social columns preferred the drama of her present persona. The ledgers recorded the assets she had amassed. And as long as the household maintained the performance, the past could be kept at a distance. At the center of that performance was also the paradox of agency. To call Ida simply a deceiver flattens the reality. To call her merely a survivor misses the complexity. She had exercised a kind of agency available to very few of her station in the 19th century, leveraging presentation, relationship, and legal maneuver to carve an independent space within a patriarchal society. Whether one admires the audacity or condemns the deception, the fact remained. She had, by the last decades of her life, constructed a private world where wealth and identity were bundled together in trunks and titles. The protective posture of that world would be tested by the shocks that punctuated the early 20th century, the periodic panics, and the shifting economy. People who studied the period later pointed to 1907 as a turning point for many households that had depended on the opacity of the financial system. The panic of that year sent depositors scurrying and tightened credit lines. For a household that had relied on both public display and private reserves, the logic of protection shifted from mere strategy to urgency. No one could say with certainty what Ida contemplated, if she contemplated anything at all. The records are spare about motive. But inventories and ledgers show that, in the face of financial turbulence, she took steps to convert negotiable holdings into forms she controlled directly. By the eve of the 20th century's second decade, the Wood household's patterns had hardened into a routine of seclusion and preservation. They remained people of social note in public, and in private, they continued the careful work of securing valuables. The trunks filled, seams were stitched, documents were placed in boxes and boxes in trunks. The household's practical rituals, what to do with cash in a crisis, how to keep securities safe, grew less like domestic habit and more like the practiced gestures of someone braced against calamity. However prudent such measures might have seemed at the time, they had an ethical consequence that would eventually transform them into a kind of crime in the public eye. For as the household's wealth became ever more hidden, a different ledger was being kept, a ledger of absence. Names missing from family charts, gaps in parish registers, the erasure of origin stories. The very mechanisms that sheltered wealth also obscured the claims of those who shared Ida's blood. The years that followed would turn that private archive into a public case. But at this point in the story, the scene returns to a hotel corridor in 1931, an exhausted woman seeking shelter, a room that resisted casual inspection, a drawer with secrets stitched into garment lining. The discovery, when it came, did not simply reveal cash and certificates. It pulled loose threads that would expose a life of reinvention and a family story rewritten at the cost of others' inheritance. As the 20th century moved from spectacle toward scrutiny, the systems that had allowed such concealment to persist, social columns, private accords, the uneven enforcement of property rights, began to buckle. Journalists arrived. The city's legal machinery stirred, and in the pages of subsequent filings, the careful craft of identity-making met the uncompromising logic of paper. Birth records, baptismal registers, and foreign parish documents became instruments of revelation. But those scenes of legal argument and archival retrieval belonged to what came next. For now the picture is of a woman who had remade herself and, in the process, had both amassed and hidden a fortune. She had built a house of identity and layered it with valuables. She had cultivated a household that presented itself as family, and in doing so she had set an inheritance table at which many would later claim a seat. The stakes of that upcoming contest, legal, moral, and social, would hinge on the paper trail and on the small, brittle items that survive human lives, certificates, registers, and the once private scraps of correspondence. Within the city's salons, and in the quiet offices of attorneys, men and women began to prepare for a fight over more than money. They prepared to litigate over erased origins and the rights of blood. The narrative up to this point had been built out of social performance, legal tactics, and a woman's relentless shaping of identity. The narrative that followed would be built out of documents, cross-checking, and the stubborn facts that do not yield to performance. Parish registers from across an ocean, entries in New England town books, and signatures on old certificates. When archival evidence later surfaced, showing that the woman known as Ida had once been documented as Ellen Walsh in England and as a worker in Massachusetts, it did more than correct a name. It reconstituted a family that had been rendered invisible by decades of careful performance. Those records did not speak of conspiracy or violence. They spoke of erasure and concealment, acts that are moral and legal in different registers. They would be the basis upon which claimants, many of them grandchildren living in modest New England households, would stake their case. But that phase of legal reckoning lay ahead. For now, the stage remained set. An old woman in a corridor, trunks full of hidden wealth, a household whose outward stability masked a family history transformed by choice. The city would soon turn its attention from the spectacle of the horde to the more prosaic work of establishing bloodlines, an inquiry that required traveling to parish registers in England, to county clerks in Massachusetts, and into the quiet rooms where birth dates and baptismal sponsors had been noted a century before. At the moment when Elm and Herald Square met in a single corridor, the trunk-sealed past of a reinvented life began to give way to the slow, relentless arithmetic of records. The people who would take up that arithmetic, the lawyers with subpoenas, the clerks with indexes, the young investigator who would follow signatures across oceans, were not yet at the center of the story. But the instruments they would use were already in place: ledgers, certificates, and the undeniable fact that identities, when fabricated, often leave traces in the places least expected. The tale that follows is thus both a study of an individual's audacity and an account of a civic process that restored, with painstaking slowness, what had been made invisible. It will trace the arc from performance to protection, from concealment to contest, and ultimately from private hoard to public redistribution. Along the way, it will ask unsettled questions about the ethics of reinvention in a society where blood and name carry both symbolic and material weight. Was the concealment a crime in the strict legal sense? Often it would be reframed as such by those who were deprived. Was it perhaps a creative survival tactic, forged by a woman in a landscape that offered little formal power? The answer would not be singular. For now, the city shuffled into place around the discovery. Reporters clipped headlines, curious neighbors remembered dinners, a few former acquaintances suddenly recalled a family likeness or the turn of a phrase. The scene that had begun with a door and a trembling request for a room had cracked open an entire life. Boxes were counted, lists were made, and the first legal notices were prepared. The hoard had been found, but the story of who it truly belonged to was only beginning to be told. Reporters arrived within days. Headlines multiplied and contorted the facts into narratives the public could hold. The eccentric recluse, the banknote quilts, the sudden fortune unearthed in a hotel room. Newsprint treated the discovery as theater, but beneath the ink lay a legal problem the city could not paper over. Close to a century of obfuscation now demanded the blunt instruments of probate, parish registers, and subpoenas. The Herald Square Hotel's proprietor placed an ordinary administrative call that became extraordinary. The city appointed a public administrator to secure the premises. A trust company was named to inventory and protect the assets. Inventories were created with the formality of legal ritual: lists, signatures, certified appraisals, because what lay in the trunks could not simply be parceled out by rumor. A short excerpt from the estate inventory, signed and docketed as an official court exhibit, read in sparse bureaucratic language as an amphora of revelation. Estate inventory, excerpt. Contents of room 712, 26 banknote bundles, assorted bearer bonds, 7 sealed boxes containing jewelry and cameos, assorted stock certificates, assorted deeds and promissory instruments, cash total pending verification. That sheet of paper, with its clinical cadence, reoriented the public appetite. The spectacle of sewn bills was dramatic. The legal machine required classification. Cash could be counted, a deed could be traced, a certificate bore signatures that could be followed to ledgers and registries. It was the paper trail, tedious, patient, and incontrovertible, that would disentangle performance from property. The flood of claimants followed as predictably as the tide. Some were mourners, neighbors who had known the woman as Mrs. Wood and asserted familial ties in a dozen forms. Others were opportunists, or so the press later suggested. People who produced old letters and affidavits that read like quick sketches of relation. Still others were professional claimants, lawyers with verbose circulars and fee agreements, eager to lodge notices of purpose in the surrogate's office. The surrogate's docket filled with petitions, heirship claims, petitions for letters of administration, motions to impound the estate. The legal spectacle made the hotel's corridors feel small by comparison. Into that swirl stepped Joseph Cox. He was not a dramatic figure in the way newspapers liked to portray detectives. He was methodical and patient, trained to read the authority of ink in the places others often skimmed. His assignment was not to provide elegy but to map truth, to locate birth and baptismal entries, immigration records, marriage licenses, and any municipal notation that would fix identity to paper. The city's attorney placed the necessary subpoenas. Cox began to travel, both in person and through correspondence with distant clerks. Joseph Cox's work is, in the records, a study in archival craft. His approach was granular. He took the inventory and matched names on certificates to company ledgers. He compared a signature on a deed with the name as presented in society pages. He cross-checked age and place of birth across disparate documents. Where possible, he sought primary sources rather than secondary claims. If a claimant produced a family Bible page, Cox asked to see the original. If a social column implied a family connection, he looked for baptismal evidence. Cox's notes, later entered into the court file, read like an accountant's ledger and a sleuth's journal at once. One entry, succinct and procedural, captured the first breakthrough. Joseph Cox, Investigator's Notes, excerpt. Parish Register located in Lancashire. Baptismal entry. Ellen, daughter of W. M. Walsh and M. Walsh. Date entry corresponds to approximate age given in U.S. records. Emigration entry in Massachusetts passenger lists possibly matches. Proceed to Massachusetts town records for corroboration. That notation marks a pivot. Where the story of Ida had been constructed by appearances and claims, Cox pursued the inconvenient stickiness of official record. In Lancashire, a parish clerk's ink had preserved the name that would complicate Ida's social legend. Across the Atlantic, a town clerk's marginalia, a ship's manifest, or a factory register would sometimes record what society columns omitted: births, origins, and apprenticeships that tethered a life to a different geography. Cox's Lancashire discovery did not immediately dissolve the household's social myth. Newspapers continued to narrate Ida as a figure who had entered society by charm and luck. But paper evidence has the habit of accumulating authority. When Cox mailed certified copies of the baptismal entry and matched them with a Massachusetts school or employment register, noting an Ellen Walsh from the same family, the pattern hardened from rumor to a documentary claim. The most consequential finding, one that moved beyond a mere origin story, concerned the relationship between Ida and the woman known to society as Emma. Contemporary press accounts had long presented Emma as Ida's daughter. Cox, examining census listings, baptismal registers, and local family notices, found entries that suggested otherwise. The parish record in Lancashire recorded 2 Walsh children born within a short span, the elder and the younger. Massachusetts apprenticeship and household entries later showed the two names appearing as wards in a single household, not necessarily in the pattern of mother and daughter as civic documents often describe. Cox's conclusion, cautious and legalistic, was recorded as such. Joseph Cox, Investigator's Notes, excerpt. Evidence suggests Emma was sibling of Ellen Walsh. English baptism entries and U.S. household registration indicate proximate birth dates consistent with sisters. Further research into guardianship papers recommended. Classify relationship as likely sister pending testimony. That careful language would be central in court. The surrogate's court does not adjudicate sentimental truth so much as legal kinship, who is an heir under statute and precedent. The difference between daughter and sister in a family tableau can mean the difference between inheritance and disinheritance. If Emma had been correctly identified publicly and in the household as a daughter, the household narrative would have assigned her a lineal stake. But if Emma was Ida's sister, the situation shifted. Ida's lineage, as legally defined, belonged to the Walsh bloodline left unacknowledged. The docket swelled with affidavits. Sometimes those affidavits were tender. An aged neighbor swore the two women had always been presented as mother and daughter, citing a social practice as evidence. Sometimes affidavits were brittle and bureaucratic. Clark certificates, census extracts, and baptismal copies stamped and sworn. The surrogate's office adjudicated on the weight of these papers. At hearings, lawyers cross-examined witnesses, not in a melodramatic courtroom, but under the measured formality of probate proceedings. Questions of chain of custody for documents, expert witness testimony on the accuracy of registers, and careful readings of statutory heirship. Newspapers loved the conflict. They printed claims excerpts and salaries of potential heirs, painting a tableau of working-class descendants circling the fortunes of a woman who had presented herself as aristocracy. Press reports emphasized the irony. Amid bread lines and soup kitchens, modest families read of their kin's sudden wealth. For many of those claimants, the money represented more than financial windfall. It was a correction of erasure. A representative excerpt from court proceedings, as reported and later transcribed into the official file, illustrates the tenor of the hearings. Surrogates' court transcript, excerpt. Counsel for claimants. We submit certified copies of baptismal and town records establishing consanguinity between decedent, known as Ida Mayfield Wood, and claimants represented herein. Counsel for administration. We do not dispute the authenticity of the copies. The question remains the legal effect given the decedent's long public identity. The technicality mattered. In many cases, decades of public presentation complicate, but do not automatically rewrite, legal descent. The surrogates considered whether Ida had executed wills, codicils, or other testamentary instruments under her chosen name, and whether any such documents were valid and dispositive. The audit found no will that clearly divested the Walsh heirs of legal claim. Instead, the documents focused attention on the object of Cox's archival research, proving lawful descent. As the hearings progressed, another practical challenge arose: the nature of the assets themselves. Much of the wealth was held in bearer instruments, assets that by design belong to the holder. Cash is cash. Bearer bonds can transfer with possession. That made some elements of the estate simple to distribute once the rightful claimant was identified. Bearer assets could be counted and handed over. Other assets, stock certificates, deeds, property, required tracing to registered records, transfer books, company minutes, mortgage ledgers. Cox traced signatures, matched seals, and located original endorsements. Where original endorsements were absent, the trust company provisionally held the asset pending adjudication. Amid the legal paperwork, human stories threaded through. Cox's investigation led him, several times, to modest New England neighborhoods where claimants worked in factories, on farms, and in small shops. They produced old letters, faded, hand-scrawled notes that proved family names, sometimes with phrases like, "Remember Mother," or "From Ellen," that resonated with the documentary trail. One group of claimants provided a family Bible page with entries that matched the baptismal entries Cox had obtained from Lancashire. Those matches, when paired with town records, supplied the corroboration the court needed. A short, moving exchange captured in a sworn affidavit recorded a granddaughter's voice. Affidavit of claimant, excerpt. My grandmother, Ellen's sister, used to say her sister went away to find a better name and would write if she could. We never heard from her again. We thought she had simply chosen another life. That affidavit humanizes the dry ledger of registers. It exposes the quiet severance that reinvention produces. Families bereft of knowledge, heirs left in the dark by a relative's decision to remake herself. For many of these claimants, the estate was not a mere boon but an acknowledgement of kinship long denied. While Cox unraveled kinship, press accounts began to feature profiles of the would-be heirs. Reporters found men who had worked in textile mills for decades, and women who sewed in small shops, households that had never known a relative's appearance beyond an occasional newspaper clipping. Small improvements in their lives, paying a mortgage, buying a warm coat, sending a child to trade school, appeared in human interest columns that read like coda to the legal saga. The scale of the redistribution, particularly in the early 1930s, carried an almost literal relief. In a country gripped by economic catastrophe, an unexpected infusion of capital into modest households altered destinies in small but measurable ways. Not all that surged onto the docket was legitimate. The economic desperation of the Depression encouraged some to present forged documents or to assert tenuous claims. The court's function, therefore, was partly forensic. Documents were compared under magnifying light, signatures were examined by experts, bank clerks were subpoenaed for ledgers. Forensics of the period relied heavily on documentary corroboration, rather than technological methods we would expect today. The authenticity of ink, paper, and chain of custody mattered crucially. Where material could not be authenticated, the court excluded it. One particularly notable thread involved the manner in which Ida had kept cash, stitched into garments, tucked into trunks, and concealed within furniture. The hoarding practice had practical logic. Liquidity in a private hand during a banking panic can be reassuring, but it also created complications. When assets are outside of bank systems, they leave fewer official markers. The surrogates therefore needed to establish provenance where the paper trail thinned. In cases where bills lacked serial numbers on existing ledgers, or where bearer securities lacked company transfer records, the court faced the knotty problem of adjudicating possession and rightful ownership simultaneously. Throughout the hearings, counsel for the Walsh claimants emphasized the principle of blood succession, that absent a valid will to the contrary, property should pass to next of kin. The administration countered with caution. A lifetime of public identity does not automatically vanish the legal identity of a person whose signatures and deeds had been executed under a particular name. The surrogate's duty was to reconcile these strands. The final ruling, when it came, read as a compromise between the letter of law and the register of social fact. After months of investigation and hearings, the surrogate's decision awarded the estate's distributable portion to the legally established heirs. 10 descendants identified through the parish registers, town records, and corroborated affidavits. The court ordered that the trust company distribute funds accordingly, after accounting for legal expenses and verified debts. Surrogate's court decision, excerpt. Upon review of certified parish and municipal records, and after consideration of testimony and affidavits, the court finds that decedent, known in life as Ida Mayfield Wood, was born and baptized as Ellen Walsh. The court concludes that the heirs at law are the persons identified in the accompanying schedule. Distribution is ordered in accordance with intestacy statutes. That judicial language, sober and prosaic, did not capture the irony of the outcome. The woman who had performed a different life had, in death, inadvertently returned her hoarded fortune to the blood she had set aside. Newspapers framed the decision as poetic justice. Social commentators offered interpretations that ranged from rebuke to relief. For some, it was a final correction. For others, the judgment was merely the beginning of further complexities. The administration's fees and legal costs consumed a portion of the estate, and the dispersal did not simply erase the years of absence. Ida's last months were quieted by court orders and press attention. She lived under the name she favored until the end. The hospital and the city recorded her death certificate under that chosen name. The public narrative, however, had changed. Her obituary, short and factual, noted the legal proceedings and the discovery that preceded them. She died in 1932, still the matriarch of a household whose public persona had outlasted her private origins. The distribution of the estate produced its own small moral reckonings. Among the 10 heirs, the uses to which the money was put varied. Some used the funds to stabilize homes and support aging relatives. Others invested in small businesses, sending younger members to vocational schools or opening modest shops. The money did not deliver immediate transformation to every life, but in several cases, it represented an intergenerational shift, a lumpen correction to economic trajectories shaped by the industrial age and its inequities. The legal cleanup continued. Creditors who asserted claims were compensated to the extent available. The trust company maintained exhaustive records of each transaction. The surrogate's office archived the files, a bureaucratic testament to the case's complexity. For historians and legal scholars, the file remains instructive, a study in how social reinvention interacts with bureaucratic memory and how law, even belatedly, can restore erased lines of kinship. In the years that followed, scholars would return to the case as a touchstone for multiple questions. Was Ida's life an act of fraud in the legal sense, or an act of survival given narrow options for women in her time? Did the household intentionally obscure heirs to deprive them, or did social performance and practical secrecy produce collateral erasure? Historians continue to debate these questions, bringing to bear new perspectives on gender, class, and property law. One historian who has written on Gilded Age identity observed, "The case is less about pure villainy than about the structural incentives that made reinvention a rational course." When social identity could unlock access to capital, many women like Ida treated persona as a form of property. A legal scholar specializing in probate practice added, "Probate law is messy because it is tasked with reconciling a person's public life with their private legal obligations." This case underlines how documentation eventually reasserts itself. Records accumulate authority over performance. Those assessments gesture toward the ambiguity that has long shadowed the story. Ida's actions can be read as avaricious concealment, pragmatic asset protection, or as a woman's strategic maneuvering within a gendered legal landscape that offered few clean pathways to autonomy. The court's language did not condemn her as a felon. It remade the balance sheet of obligation and entitlement. There are ethical textures that legal rulings do not capture. The Walsh descendants, when interviewed years later in regional newspapers, expressed a mixture of astonishment and conflicted sentiment. To inherit was to receive both relief and the odd sensation of vindication. Some felt resentful that a relative had chosen that removal. Others felt sympathy for the difficult calculus that might have driven someone from poverty to the creation of an alternate identity. These responses underline the complexity at the story's moral center. Identity, once remade, leaves wake and wreckage. The public fascination with the case did not entirely subside. The story fed into broader cultural narratives about eccentric wealth, about recluses with secret stashes, and about the redemption of rightful heirs. It also joined the legal canon as an instructive example of how probate courts address contested intestacy complicated by decades-long misidentification. Beyond courtroom and paper, the case is a study in containment. Ida had contained cash, certificates, and relationships, insulating aspects of her life to preserve privacy and control. Those same acts of containment made her vulnerable to being undone by the very records she had hoped to escape. The sewn money, the sealed trunks, and the staged household were practices of keeping money, identity, and distance. In the end, those practices mattered less than the ledger, parish entries and clerk notations that can, with time and patience, undo the most elaborate of performances. The irony is, perhaps, the clearest moral note. The money that was hoarded in a room, sewn into nightgowns and boxed in trunks, eventually passed to the blood she had displaced. That transfer was not melodramatic revenge. It was the legal resolution of intestacy, informed by documentary verification. The estate's return to the Walsh descendants reads like an enactment of restitution, a reallocation of capital that might otherwise have remained in private opacity. Still, the moral question resists a tidy verdict. Was Ida a criminal for having kept these funds secret? The law, in its final formulation, framed the issue in terms of rightful descent and property claims, not as a question of felony. The ethics, however, provoke a sharper debate. Deception served as a strategy of survival and social climbing, yet reinvention carried the cost of erasing family and obscuring claims. Whether Ida deserves applause for ingenuity or censure for familial erasure depends on the vantage point from which we view her life. The broader social context further complicates judgment. In an era when women's legal rights were circumscribed and when a woman's social standing could dramatically affect her economic options, reinvention offered access. At the same time, the accumulation of private capital outside of legal channels during periods of financial panic had destabilizing ethics. It preserved wealth for a few, while exacerbating scarcity for many. The case sits at the intersection of those tensions. In the years since, the case has informed scholarship on inheritance, identity, and the social history of the Gilded Age. Archivists point to it as an example of the importance of cross-jurisdictional research. Parish registers in Lancashire held the keys to an American probate dispute. Legal historians use it to illustrate how surrogates courts mediate the collision between performance and paper. Cultural historians read in it an instance of how persona becomes capital in a modernizing society. There is a scene worth returning to, one that bookends the narrative with the clarity of its symbol. Imagine, in the same dim corridor where a trembling hand first asked for shelter, the trunk once sealed being opened under a different light. This time the trunk is not a private vault, but an exhibit in a courtroom. The nightgowns, once repositories of cash, are displayed for inventory. Banknotes are counted in the presence of clerks and witnesses. Certificates are catalogued and matched to ledgers. What the trunk yields there is not merely cash. It is evidence in a civic process that returns money to a different moral ledger. In that final unsealing, the drama of reinvention meets the prosaic mechanisms of law. The sewn bills, which had functioned as secret bulwarks against economic uncertainty, become the very instruments of restitution. The physical act of opening the trunk and counting its contents marks the transition from private concealment to public adjudication. The same object, bundles of banknotes stitched into cloth, can be both an emblem of personal agency and an index of familial erasure. Ida's life and its legal unraveling hold lessons that feel oddly modern. They compel reflection on how identity is manufactured and what obligations persist despite performance. They ask how law and record can repair, albeit imperfectly, the acts of erasure performed by one person's project of self-making. They force us to reconcile admiration for a woman's audacity with sympathy for the kin she left behind. When the final accounting was made, when the checks were cut and distributed, the surviving members of the Walsh line took, in many cases, practical steps, paying debts, buying small parcels of security, and investing in the education of children. The money reshaped certain lives, but it did not and could not restore lost years or reverse the silence that had separated families. That is a human cost the court's ledger did not and could not enumerate. Ida herself, who had once walked among gaslights and social salons, remained even in death a figure of contradiction. To some she was an audacious survivor who had forged agency in a hostile world. To others, she was someone whose secrecy amounted to a moral trespass. The surrogate's decision did not resolve those moral categories. It settled legal claims and redistributed capital. It also invited an enduring public conversation about how societies remember and adjudicate identity. The case closed in paper, but opened into memory. Later generations read the archived files and find there both the banal work of office clerks and the human traces, inked signatures, brittle affidavits, and the faint pencil notes of an investigator who followed a name across an ocean. Joseph Cox's patient labor of cross-reference remains the backbone of the story, a reminder that records, however spare, can attempt the work of truth. As the city moved on, the hotel corridor returned to its ordinary anonymity. The trunks were emptied, the room cleaned, and the hotel continued to register guests under their names. Yet the image persists: the old woman in worn shoes, the drawer that would not yield, the nightgown with a private fortune sewn into its seams. That image furnishes a parable about the cost of remaking oneself and about the stubborn power of paper. If the phrase, "the crime the family tried to bury," carries a sting, the case warns us to calibrate language to fact. There was no violent transgression, no physical conspiracy to silence others. The crime, where it applied, was in omission and in concealment. The deliberate erasure of origin that obscured rightful heirs, the private accumulation of wealth that deprived kin of notice and access. Those acts, once revealed, were litigated and remedied as the law could. The resolution, however partial, restored, in a manner consistent with probate practice, the balance between blood and property. In the final account, what was buried was not a corpse, but a lineage. The legal process, slow and procedural, exhumed that lineage and reconnected it to capital. The irony is plain. The funds hoarded to secure a life of reinvention eventually flowed back to the blood that had been left out of the staged family portrait. The story's last scene returns us to a domestic ritual that had carried so much meaning. The opening of trunks, the counting of bills, the cataloguing of objects that mark a life. In the end, those rituals were civic as much as private, the materials of a private life entering the public record and reshaping communal fates. The trunks that once sealed the chosen identity became, in the hands of a court and its clerks, the instruments by which the past was made legible and redistributed. In that redistribution, there is no tidy moral closure. The Walsh heirs received money and recognition, but the years of absence and the social distance Ida had built were not amendable to even the most generous accounting. The case remains a study in the limits and capacities of law to reconcile identity and inheritance, and a story that asks, persistently, how we weigh the costs of reinvention. If there is a final thought to linger on, it is paradoxical. Reinvention can be both liberation and erasure. In Ida's life, those forces coexisted. The lesson is not a counsel against change, so much as a caution about the relational costs of absolute reinvention, the names unspoken, the claims obscured, the kinship unrecognized. The law, patient and slow, will sometimes correct for those omissions. It cannot, however, restore the lost exchange of life that might have occurred had truth been chosen sooner. The trunks were closed again. Files were shelved. The city moved forward in the depths of the Depression, and the people who received the estate's distribution used the funds for ordinary, necessary things. The memory of the sewn money, of the hotel corridor, and of the careful investigator who followed inked lines across oceans lingered in archival boxes that scholars still consult. The case endures as a cautionary and instructive tale about identity, secrecy, and the modes by which a private life becomes public business. If this story leaves a question unanswered, it is this: when does reinvention become a moral wrong against those we leave behind? The legal answer is sometimes clear. The human answer is often tangled. In Ida's life, both threads are visible: the audacity of self-fashioning and the quiet, irreducible cost of erasure, leaving us to ponder who, in the end, pays for reinvention. If this account moved you, leave a comment sharing which side of the question you find yourself on. Was Ida a survivor who did what she had to, or was she culpable for the erasure of her kin? Share this story with someone who appreciates long-form history, and check the description for a list of primary sources and archival collections used in this investigation.